Hello out there, this is the Irate Veteran coming at you with another video. Before we start, let me thank my sponsors. Let me read this little disclaimer. I am not recommending any specific lawyer or law firm to veterans. Veterans need to conduct their own due diligence before selecting a lawyer or law firm as their representative. Mr. Greg Rada and Wesson Dunn are my sponsors, and thank you very much for being my sponsors. Okay, veterans, we're going to talk about special monthly compensation today. And I have a guest with me, one of my sponsors. Let her introduce herself. If you would, please.
My name is Shana Dunn. I'm with the law firm of West and Dunn in Wisconsin. And we are a law firm that specializes in providing disability benefit assistance to veterans, support them in filing their appeals at the regional office level, at the board, and at the Court of Appeals for Veterans Claims.
All right, veterans, here are the pay levels. And if you notice, the big ones start like at S, but then L, M, N, O, and R1, R2, T. So it moves up in how much the compensation is. And basically, that's all relevant to how serious your disabilities are. But if you notice at the regular 100% rate, even S pays $450 more than that. When you get to L, we're talking, $900 more. So it's really a big deal. If you qualify, you absolutely will be able to support your family much better if you follow the service connection path, should you have these issues. So let's just jump right into one of the things lots of veterans have. What I see mostly on SMC K is people with female sexual dysfunction or erectile dysfunction, but that's not what it's just about, right?
Yeah, you can see here in the regulation you have printed that there are a number of ways you can qualify for SMC K. Those include like loss of use of a hand or a foot, loss of use of both buttocks, which means that you're unable to get up from a seated position without using your arms, creative organ issues, which you've covered, and then blindness in one eye, light perception only, or deafness in both ears. And then finally, organic aphonia, meaning you have the complete inability to communicate by speech. So there's a number of ways to qualify for SMC K, but I agree most often we're seeing that loss of use of creative organ as the most common way to get that SMC K rating. Now you can have multiple ratings, so it's certainly possible to get the SMC K for loss of use of a creative organ and then get another SMC K rating for loss of use of a hand, another one for deafness. There's almost infinite combinations in this SMC realm.
I do have a question on, let's say someone had a hysterectomy or even a veteran that lost the use of both feet. Those are separately compensated under the schedule. Do they still get K?
Yeah, so SMC K and all SMC really is a payment on top of whatever evaluation you're getting for the disability itself.
Okay, great. And you can have like up to 3 Ks?
Yeah, so you can definitely stack them, but when you get into multiple like loss of use issues, we're going to see in the next few slides that starts getting into the higher levels of SMC rather than stacking Ks.
Okay, great. All right, veterans, here's the web address, and really there's a great explanation if you go to this page, and it says learn how we assign levels L through O. If you look, here's what it says under L. You kind of can see there's 3 groupings, one involving amputation, and then one for loss of use, and then another group for bedridden, aid and attendance, and the need for daily help with basic needs is aid and attendance, and then loss of sight, blindness. So there's like different groupings for how they do it. And as you move through the schedule and you look through it, here's like O, and you can see there's some very, very serious disabilities here. And most veterans that I've worked with don't have these. Even if they go and get to O, there's usually follow a different path. And we're going to talk about those different paths. One of those is at the bottom, these 2 different disabilities or situations listed under L, M, or N. Let's go back to L for a second. How would that work exactly here? Is there a possibility looking at this where 2 different situations could lead to O?
Yeah, absolutely. So even under L, if you've had one foot amputated and loss of use of one hand, that's one qualifier for L. If you've also had another foot amputated and I guess that doesn't work. You have to find two of these that you qualify for.
So for example, let's say that I had lost the use of feet and that I had aid and attendance based on PTSD, for example.
Exactly. Yeah. So essentially, when you're looking at any SMC rating, you've got to kind of look at each of your disabilities that might qualify you for SMC. So any loss of use you're dealing with, any anatomical loss you're dealing with, anything with your vision, that's getting into the blindness range, hearing, getting in the deafness range, and then dig into these regulations to see, because all of these combinations, there's so many different combinations that'll get you to a particular level, but that O level, 2 separate qualifiers for level L through N will get you to O.
Yeah, so I know we're not going to go through every one of these, of course, but the typical paths, if you were to look through L through N, I mean, this is basically what I see most veterans do. It's the loss of use of feet, knees, hands, hand and foot, and then aid and attendance. So that's kind of how they get there. So let's talk a little bit about, for instance, aid and attendance, which is one of the big ones to get into L.
Yeah, I think aid and attendance is what I see more than any other qualifier for L.
What I see sometimes is problems with the form the way it's filled out. In one of the blocks where provide a complete diagnosis with most significant symptoms for each condition, sometimes here I'll see that it seems like the doctor isn't aware of the things a veteran service connected for and doesn't list all of those. We kind of have to be careful when we get this form filled out.
Yeah, I certainly wouldn't want any diagnoses included in this form that are for non-service connected conditions. You'd want to keep them pertinent to service connected conditions, even if you have other disabilities that are not service connected. The doctor should just keep in mind those service connected disabilities and then do the best to describe exactly what limitations the veteran is experiencing and what sort of assistance that veteran needs with his activities of daily living.
So if, for example, okay, let's say the doctor, did the right thing and listed the diagnoses that are relevant to service connection and then checked these boxes that you require assistance. I mean, do you need more than one box checked? Or, I mean, let's say I only needed help with medication management. Do I still qualify or do I have to have a number of these boxes selected?
Well, I think, if you read the regulation, I don't think you need to have a certain number of the boxes selected, but I think you do need assistance with those activities of daily living. And the activities of daily living that are pointed out in that regulation consist of bathing, showering, eating, meaning physically eating or the ability to feed oneself, not needing help with preparing meals, dressing yourself, being able to move around your home without being in danger of hurting yourself, tending to hygiene, so using the toilet, using the bathroom, shaving, things like that, getting in and out of bed. Those are the kind of things that VA is looking for in that regulation. If the doctor only checked medication management here, I don't think that would be enough. I do think if they only checked bathing or only checked toileting, that it would be.
Yeah, so actually, I don't think I've ever seen just one thing checked. Normally there's veteran with, even if they need help with medication management, that usually surrounds, maybe memory type issues. They may need help in other areas. But anyway, so this is one of the things that a veteran needs to have aid and attendance if he's going to qualify for R1, R2, or SMC T. It's a requirement for those particular levels. So veterans, if you start needing help due to your service-connected disabilities, don't wait to apply for this.
Yeah.
Because you don't know what the future holds, right?
Yeah.
You may at some point qualify for R1, R2, or SMC T.
I do think too that it's important to point out that the veteran doesn't actually even have to apply for this, right? The onus is on VA to consider whether aid and attendance is warranted in any particular situation. Now, that doesn't mean they're always going to have all the information they need to make that determination. But, anytime VA assigns 100% disability for something, they should be thinking about whether aid and attendance is necessary. And it is something that they miss pretty frequently.
I've actually never seen them actually say, looks like you need this, right? But yes, you're absolutely right. So veterans, you may have some eligibility for earlier effective dates once
Exactly.
you get it approved. All right, so let's kind of move on into, here's one of the really big ones for the loss of use of extremities, for the lower extremity and the upper extremity, is that there is a part of the DBQs for these particular appendages is that they have a certain checkbox, and it says, yes, functioning is so diminished that amputation and prosthesis would equally serve the veteran. And really, if you don't get that box checked, you can pretty much forget about getting loss of use approved. But at the same time, I think there's a lot of people who fill out these forms, whether it's a PA or an MD, that they don't understand the definition behind loss of, because we're not talking about having to be in a wheelchair, right? Or something like that. So could you kind of give us a definition or, explanation of what does that mean is equally served?
Yeah, I think what's important is to think about, how does a foot function versus how does a prosthetic foot function? You lose when you have a prosthetic, some of those abilities to propel yourself, the movement in the foot that's there when you have your actual foot fully functioning. Propulsion, proprioception, understanding where your foot is in space. With your hands, the ability to manipulate and grasp fine objects. So you have to make the argument, if you're not getting this box checked, that says, well, here's what my foot can still do, and here's what a prosthesis could do. And those two things are essentially the same, right? I'm missing all of those functions that a normally functioning foot would give you. And instead, what I have is more like a prosthesis. There's something there, but it's not able to do all of these fine motions that my foot would have in the past. So sometimes you're going to have to make that argument in a little bit more detail and really kind of point out to the examiner or to the rater that, yes, you are missing enough function in your appendage that you would be equally well served by prosthesis.
And that's one of the places I think a statement is so important for veterans to really clearly and fully explain their function loss. How long can you stand or walk or go upstairs or whatever it might be, lift or reach. That written explanation by the veteran would help a representative construct an argument around that. Veterans out there definitely do good statements.
Yeah, the more detail you can provide, the better, right? Because you're the only one that can feel most of these things. And so you're the only one that can provide that information. Even somebody examining you is not going to know, kind of the minutia of exactly how your body is serving you, given your disability. You're going to have to tell them.
Yeah, exactly. And, that's one of the reasons that I always have supported representation by lawyers specifically, is because they can construct a proper argument around the facts. And that's one of the things I see mostly is veterans don't know how to construct that argument. They may know their facts, but they just don't know how to put it together in a way that presents a narrative that helps them win the claim.
Yeah.
So anyway, let's move on to SMC. I found this amazing when I read through how this works. So, and let me flip back to this first chart here, veterans, where you see the halves, right? There's L and a half, M and a half, N and a half, right? So when you get to read this, now that kind of makes sense how we get to the half, right? Mm-hmm. So could you explain how this works, this half and full basic jumps in the L rate or in the SMC level?
Yeah. So once you're 100% getting SMC L, you're able to make that jump or move up kind of half step or full step by step if you have additional disabilities that are rated at either 50% or more or at 100%. So if you have an additional 50% disability, for example, 100% for PTSD, 50% for sleep apnea, that can move you from L to L and a half. If you have an additional,
so basically like this. So I mean, yeah, you can get all the way to O with these types of jumps.
Yes,
and that's why when veterans ask me, and I've been asked it a million times, right? Well, I'm at 100% now. I'm just going to stop. You may in fact be robbing yourself if you have other disabilities I've always advised veterans to follow through with them because you don't know what the future holds. And just like this, let's say you had 100% for loss of use of your feet and you decided to stop, even though you may also have PTSD and OSA, then you would lose out. Veterans always, if you have disabilities that are related to service, follow through, because if in fact you qualify for an SMC, you might be able to get these half jumps or full jumps in level to O. And as we've seen, the difference in pay is, I mean, it's just huge between a normal 100% and at the O level, we're talking over $6,000. So it's a big deal. So veterans, you should definitely follow through with more of these service connections should you have them. Okay, now here's, I get a lot of questions on R and R2. So there's some basic qualifications for it. You have to be at O and have AA, and you can get to R1. It seems pretty simple. If you can get to O, that's the big one, and have aid in attendance, or N.5 plus K plus aid in attendance, you can get to R1. R2, there's a difference in the AA. I mean, so there's two different levels of AA. Could you talk about those?
Yeah, so for R1 or for SMC L, aid in attendance, VA is just looking for whether you require assistance with the activities of daily living. It doesn't have to be assistance from anybody in particular, it just has to be that you require that regular assistance. When you get to R2, VA is looking for requirement of some sort of medical assistance. So assistance provided under the direction of or actually by a licensed medical professional. So this could be like a home health nurse coming to change catheters or dressings that need to be changed, things like that. So your spouse could certainly be providing these services for you most of the time. They just have to be working under the direction of your doctor or physical therapist or some other licensed medical professional.
So the difference is, one is my wife can help me with, my daily needs. Then for the next level, for like R2, if I qualified, it has to be some kind of specialty medical care, even though my wife maybe still can do it, as long as she was, instructed of how to do it by someone who knows.
Exactly. Yep.
Do these assistants, have to be like permanent? For example, I know physical therapy sometimes has a limited duration, right? You might have 10 sessions during any calendar year or less. Is this something that always has to be ongoing?
I guess that would depend on what's happening in the interim. If you're getting physical therapy for 10 sessions and then maintaining that at home with the assistance of someone else, I think that could potentially qualify. I think if you have a limited need for physical therapy for some sort of acute flare-up, then that would be a different situation.
Right. So we're looking at something that's long-term, necessary for the welfare of the veteran. Now let's go into S. This is one of the ones I see more than anything else.
Yeah.
And could you cover that? Because, they call this the housebound rate, but you don't actually have to be housebound to get the housebound rate.
Yeah, I don't, you rarely see this due to actually being housebound, but this is the rate that VA assigns if you have one single disability rated at 100% and then another disability separate from that 100% rated at 60% or more. So that's what they call the housebound rate, but actually is just a scheduler requirement that you have those two evaluations. And you made this note here that unemployability does qualify for that 100% rate. It just has to be separate and apart from that additional 60%. So if you have one disability that's causing your unemployability and a totally separate disability that's not contributing to the unemployability rated at 60% or more, then you can still qualify with unemployability.
Yeah, so I know quite a few veterans, and it doesn't have to be one thing at 60. It could be, 3 or 4 things. As long as it VA math-wise goes up to 60, you qualify for SMC S. Although this is one of the lowest level SMC payment, it's still, like I pointed out in the beginning, a substantial increase over the regular 100% rate.
Yeah, and this is one that I think
VA missed this one quite a bit, actually.
I was just going to say the opposite. This is one that they do actually get sometimes, but you're right. There are certainly situations where they miss it. And I would say in particular, like you pointed out, where it's not simply a 100 and a separate 60, but a 100 and maybe a couple of other conditions that could combine to that 60.
Right. So now let's go on. And when this first came out, SMC T, which is what, a couple of years back, I don't know how many phone calls I fielded from veterans with traumatic brain injury who were like, okay, I'm going to get this one. It's not as simple as that. It's like there's a bunch of ands here, right? It's TBI and need for regular aid and attendance and be not eligible for R2 and in the absence of regular. So there's a bunch of terminations that have to be made here. Do you see this much? And do you see any problems with veterans reaching this level?
I do see a lot of people going for this. I don't see very often people who actually qualify because of this last point, right? In the absence of the aid and attendance would require hospitalization, nursing home care, or other institutional care. So this is a very serious brain injury. This is not any brain injury. And so I think that there was a lot of publicity when this came out, and I think a lot of people took it to mean that this was available essentially to anybody with TBI. But there are those requirements, and this is really a benefit for the most disabled veterans. And you could see that, just based on the amount of money associated with this award, right? It's over $10,000, triple the monthly payment for the 100% benefit. So I do think there's a little confusion about that.
And there's another element here that's interesting where it says in need of regular aid and attendance for the residual traumatic brain injury. So it's not as simple as needing aid and attendance. If, for example, you have loss of use of your feet and you need aid and attendance for that, well, that's not going to help you with this particular rating because your disability has to be specifically related to the traumatic brain injury. I imagine, though, if you had a traumatic brain injury that affected the nerves going to your feet, maybe that would qualify, right? But again, it has to be specifically for the residuals of the brain injury, why you need aid and attendance, which is kind of another stumbling block. I worked with several veterans on claims like this, and their aid and attendance needs typically aren't solely due to the brain injury.
Yeah, so that brain injury would have to be the injury that satisfies all of these criteria, right? The residuals of that. And, people with TBI still qualify for all the other levels of SMC, even if it's the TBI that's causing those SMC qualifying disabilities. So it's not like you're limited to SMCT if you've got a TBI. Don't overlook some of these lower levels because it may very well be that you don't, have a disability that qualifies you all the way at the level T, but you maybe just need regular old age and attendance versus this higher level care.
Right. So anyway, I think we pretty much covered all the different levels. Is there anything else you want to say about special monthly compensation?
I think in general, there's as we said, almost infinite different combinations of disabilities that could qualify for some level of SMC. And so I like to think about anytime you get 100% evaluation, anytime you get an additional 50% evaluation, if you've got a serious disability of the feet, of the hands, of any appendage, start thinking about that SMC and whether you meet those criteria. It may take a little bit of convincing to VA if you don't have very clear loss of use, and you may have to do that work to kind of suss out those symptoms and make that legal argument as to how those symptoms fit these criteria. But those are my, red flags for thinking about SMC is really highly rated evaluations of any of the extremities, 100% evaluation, and then obviously TBI as well.
Yeah, so I just want to make sure veterans out there get what they, have earned. Veterans, don't think that you're not deserving of some of these higher paid rates. If you have these issues, file claims and, let the VA make the decision. If you qualify, then you should get compensated for that. All right. Well, then, veterans, Irate Veteran out.